Mr. Muha, really directed at all of you. This appeal has to finish by 4:15 at the latest. So I hope you've discussed between yourselves how you divide up the afternoon in order to give Lord Panic enough time to reply.
The friends indicated I think you need up to an hour, and I don't anticipate that being any problem.
Right. Okay.
My Lord, I don't need to say anything much further on the OECD bribery convention than I've already said. It's concerned solely with criminal jurisdiction. It has no relevance to the question whether the United Kingdom has a treaty obligation to decide civil claims. Can I turn then to the UN Convention against corruption? And my Lord, I wonder if I might, and actually also this might help in terms of speed, I wonder if I might take this from our skeleton, because there are some materials I need to show your Lordships, and some of the cross-references, for which I apologise, are not correct. So it's going to be easier and quicker to pick it up on that way, in that way. In our skeleton, paragraph 52 on page 19, and the convention is bundle 8, tab 54.
Sorry, what paragraph in the skeleton?
It starts at 52 at the bottom of page 19, bundle page 172.
Right.
And in fact, I'm going to pick it up, if I may, at paragraph 53, and ask your Lordships to look again at Article 26, bundle 8, tab 54. Bundle page 2462. My learned friend showed you this article, and I emphasise in Article 26.1 the words, so each state party shall adopt such measures as may be necessary, consistent with its legal principles, to establish the liability of legal persons for participation in the offences established in accordance with the Convention. Paragraph 2, subject to the legal principles of the state party, the liability of legal persons may be criminal, civil or administrative, and accordingly that would not create any obligation on the United Kingdom to override its principles of act of state.
Well, subject to in both cases means in accordance with, doesn't it?
Yes, indeed. So there is nothing there which directs how state parties as to content of their law and legal principles.
Is that right? I would have thought in accordance with the legal principles was going to form.
Sorry,
was going to form, not substance. It's a matter for the states how they formulate it in accordance with their legal principles. They've got to adopt the measures.
Lord, no, and I'll show you in a moment, Lord, but I would, well, Lord, I would say no, that's in relation to substance. I would say that's also confirmed by, if one looks at Article 35, on page 2467, each state party shall take such measures as may be necessary in accordance with principles of law to ensure that entities or persons who have suffered damage as a result of an act of corruption have the right to initiate legal proceedings against those responsible. And again, I would contrast that, I mentioned this earlier, I would contrast that with the wording in the Torture Convention. If you will just keep a finger in 2462 and go to tab in tab 51, bundle page 2432, the wording of Article 14 of the Torture Convention. And I'm going to show you, Lordships, again, this is, I'm going to show you, Lordship, what one gets from the Travaux Preparatoires, which again will, I think, shed further, as the Lordships will see in a moment, shed further light on it. It's clear in our submission that Article 35 is not seeking to establish a universal an obligation on member states to establish a universal civil jurisdiction or even a right to an effective remedy in individual cases. The paragraph 58 of the skeleton, if I can take you to the Travaux, this is in bundle 9. Tab 61, the last tab in the bundle. If you go to bundle page 2624, at the bottom of the page you see under the heading B, approved text adopted by the General Assembly, the text of Article 35. And then over the page, section C, interpretative notes. The interpretative notes on Article 35 of the Convention approved by the Ad Hoc Committee and contained in its report on the work of its first and seventh sessions are as follows. B, this article is intended to establish the principle that states parties should ensure they have mechanisms permitting persons or entities suffering damage to initiate legal proceedings in appropriate circumstances against those who commit acts of corruption, for example, where the acts have a legitimate relationship to the state party where the proceedings are to be brought. While Article 35 does not restrict the right of each state party to determine the circumstances under which it will make its courts available in such cases, it is also not intended to require or endorse the particular choice made by a state party in doing so.
Yeah.
It's worth contrasting that with what had been an alternative draft text that had been proposed to the drafting committee, and you can see that at 2622, back a couple of pages. Under option 1, so this was a draft proposal. Option 1, each state party shall ensure that its domestic law takes account of the need to combat corruption and provides in particular effective remedies. Those words were not accepted and were not, and obviously not then in Article 35. In our skeleton, this is the first sentence of paragraph 59. The cross-reference at the end of that first sentence should be at 296, not 299, and that's bundle page 2622. And we also and I also emphasise the point I show you in the interpretive notes that Article 35 is intended to establish the principle rather than the directive as to the content of the law. Can I show your Lordships some commentary on Article 35 at tab 59 in volume 9? just to confuse your lordships, you may have at the front of tab 59 a cover page from a book on the UN Convention on the Law of the Sea.
Yep. Very helpful.
And I wasn't proposing to address submissions on why that's there, and it can be removed. But if you go over the page, you will see another cover page, which is of the text from the Oxford Public International Law series by Rose, Cabusiel and Land there. And if you go to page 2607, in fact, can I ask your lordships to read, again it'll be quicker, can I ask your lordships to read in from section B for the true scope of Article 35. The two paragraphs on that page are going over the page, and then the paragraph over the page beginning in this view, the sidelined parts. And my lords, just while I'm correcting references, then in paragraph 59 of our skeleton, line 5, the reference there just before Rose should be Travaux at 299. And also, if you would turn back a page in our skeleton, paragraph 56, the Article 14 of the Torture Convention, which I've showed you, the margin cross reference there is incorrect and should be, so it shouldn't be 854.2457, that should be 8/51/2432. So, my lords, we say it is clear that Article 35 does not impose a treaty obligation on the United Kingdom in relation to the content of and how it chooses in its discretion to provide the right to initiate claims based on bribery. But in any event, as your lordships know, we say even if the appellant's contention were correct, that would be no more than an unincorporated treaty obligation. And the fact that Parliament had not given effect to it in domestic law would point to the absence of there being English public policy in terms of mandating civil courts to decide such claims and override act of state. And then, Lord, the last instrument on which my learned friend relies is the European Convention, the Council of Europe Civil Law Convention, which has not been ratified, has not entered into force. Again, doesn't create an obligation, and none has been incorporated into English law that requires the court to take subject matter jurisdiction.
It has entered into force. We've
Sorry,
not ratified
apologies,
it.
has not been ratified, apologies. Has entered into force, has not been ratified.
Yeah.
Can I, my lord, my lords, can I address my own friend's point based on Article 18 of the Vienna Convention of the Law of Treaties? First point is that in circumstances where the Convention has not been incorporated into domestic law, let alone ratified, it therefore imposes no international obligations on the United Kingdom in that respect. It is true, of course, that Article 18 of the Vienna Convention imposes an obligation to refrain from acts that would defeat the object and purpose of a treaty which has been signed but not yet ratified, and that would include this convention. But reliance on Article 18 doesn't assist the appellants for, for two reasons. First, as an unincorporated treaty provision, it hasn't been given effect in domestic law, and it is well established that as a general rule, unincorporated treaty obligations are non-justiciable and have no direct effect in English law. If authority was needed for that proposition, the Supreme Court in Lord Bencher at paragraph 157 and Lord Sumption in Belhage at paragraph 252. Secondly, the executive, which has exclusive responsibility for the conduct of the United Kingdom's foreign relations, has indicated that it does not consider the signing of the Civil Law Convention to entail any obligations to change domestic law in any way. Your Lordships will recall the extract from Hansard that my learned friend took you to, bundle 9, tab 60, the next tab at page 2617, where the statement was made by Jack Straw that the United Kingdom takes its international obligations seriously, and this House should be in no doubt that our law is already compliant with the various international conventions combating bribery to which this country has put its name. That formulation would include not just the ratification of the UN Convention and the OECD Convention, but also the signing of the Council of Europe Civil Law Convention. Plainly, the executive has taken the view that no further obligation flows from the United Kingdom's signing of the Civil Law Convention 10 years earlier. And the executive must consider that there is no requirement as a matter of international law flowing from the Civil Law Convention, even read with Article 18 of the Vienna Convention, to give effect to Article 3 of the Civil Law Convention. Put another way, the executive plainly consider that nothing in domestic law as it existed in 2010, which would include, of course, the existence and potential application of Foreign Act of State, defeated the object and purpose of that treaty. It is not the constitutional role of the courts to second-guess the executive's determination of what is required as a matter of the United Kingdom's international law obligations, or to what extent those obligations are to be given effect in English law. Likewise, it is not appropriate to ask the court to find that the application of Foreign Act of State would somehow place the United Kingdom in breach of its unincorporated treaty obligation under Article 18, which appears to be the submission. Finally, the international obligation under Article 18 of the Vienna Convention exists for so long as the state party has made clear its intention to become a party to the treaty. Learned friend says there is no evidence that the United Kingdom does not intend to ratify the convention because it has made no statement to that effect. An intention not to become a party to a treaty does not have to be expressed. It can be implied from conduct. The appellants rely on statements made in Parliament, which they say confirms that the United Kingdom intended to ratify the convention. But those statements were made about 20 years ago, and the appellants can point to nothing since which indicates that there is now a continued intention to ratify the convention. So for those reasons, we say the appellants cannot establish, by reference to any of the instruments, which in any event have not been incorporated into domestic law, a public policy creating an obligation on this court to override Act of State if it would otherwise be applicable under our law.
It isn't. Forgive me. It isn't a matter of overriding it. It's a matter of determining the scope of it or the extent of it, recognising the limitations and/or exceptions. So it's not as though there is a clear-cut case of Act of State which is being overridden by international obligation. It's a matter of interpreting the scope of Act of State, taking into account that it is well recognised that one of the exceptions or limitations is international law or policies as reflected in English public policy. It's not such a black and white question as that, is it? It's a more nuanced question.
It is. Well, it's binary in the sense that because if we're considering the exception, it's on the basis that there would otherwise be, it falls within the Act of State rule, and then the question is whether the case falls within the exception. The Act of State rule is a mandatory rule, a rule of abstention, and so it is binary in the sense that what would then be needed under the exception is a public policy which mandates an imperative to the court to decide.
Well, I'm not sure from what I've seen that it's quite so crystal clear. This law assumption makes reference to the fact that one can draw public policies from the criminal law.
Not to draw it from the criminal law that there's still the further step which the Supreme Court went in Belhaj on the basis of the criminal law, then to find that there was, in relation to the civil law, there was an imperative and a public policy obligation on the court to decide the civil claim.
Well, as I see, you're putting it very high as I understand it. You're saying that the exception can only arise if there is a clear obligation on the English court to effect such an exception. And from what you've shown us from the authorities, I'm not quite so sure that such a clear-cut statement is justified. Everything we've seen, the wording is a little bit more vague than that, and references to international law and English public policy seems to me is replete with an open textured nature, not capable of being so pigeonholed.
Lord, and apologies if this is going back to points I've already made, but the reason I make this submission is because I say that the starting point for considering any question in relation to the application of the exception must be founded on a proper understanding of the nature of the Act of State rule.
Yes.
As soon as one recognises, as is clear, that it is a a rule of abstention, then one must be asking the question, what is it that is going to make the court not abstain, in other words, decide? And that's why, my lord, I say that it isn't simply a question of identifying in a loose sense a public policy, as in bribery is contrary to public policy, or any of the bad conducts that arise in Act of State are themselves contrary to public policy. It's an exception to the Act of State rule, and therefore has to be a public policy to decide the case in circumstances where the Act of State rule is a rule that the court should not decide the case.
Well, we have the statement by Lord Jones at 1362. Seems that statement, it seems to me, is about as far as I can put it at the moment. With the further elucidation that we've seen from the authorities who referred it.
Well, indeed, but the elucidation in the authorities is quite clear that it is a rule, that the Act of State is a rule of abstention.
Yes, of course it is. That's exactly what it is. But
Yes.
that doesn't help us decide with working out the content of the exceptions.
But it helps to this extent, my lord, that it means that it is the abstaining which must be contrary to English principles of public policy.
Yes.
That's the only point I'm making. And if it's the abstaining which must be contrary to public policy, that means you're looking for a public policy which tells the court that it should not abstain.
Well, that's not that isn't actually the way that it's put by Lord Jones, is it? It's that it will not apply to foreign acts which are in breach of or contrary to, or where there is a grave infringement of human rights. So that's certainly the way it's formulated there. You look at the acts and say whether they are contrary to public policy.
Lord, I agree that it's compressed. And Lord Lloyd Jones is not purporting here to have an extended exposition that covers what is established in authorities, though he refers to the discussion in UCOS Capital, and that's why Lord One and my own friend showed you, and I showed you the other material in the Supreme Court, and in particular in Supreme Court judgments, and in particular in Belhaj, that does elucidate it.
Thank you.
My Lords, Article 6 it is accepted by the appellants common ground that Article 6 does not in itself guarantee any particular content for civil rights and obligations in the substantive law of contracting states. And the Strasbourg jurisprudence establishes that the question whether the creation of immunities engages Article 6 depends on whether the rule is procedural or substantive. And in that regard, the Strasbourg court looks to national courts for the correct characterization of the domestic law in question. The judge held that Article 6 is not engaged if a claim is dismissed on Foreign Act of State grounds, and it is our submission that he was correct so to do. That question has been directly considered by the Supreme Court after the fullest of argument in Belhaj, and although in the event it was not necessary for a decision to be reached in order to dispose of the case, 3 judges of the Supreme Court, as your Lordship saw yesterday, said that Article 6 was not engaged and explained why, and no contrary view was expressed by any other member of the 7-judge court. and in our submission there is no reason to take a contrary view in this court. As my learned friend showed you, in Belhadge, Lords Mance and Sumption, with whom Lord Hughes agreed, all found that foreign act of state was a substantive restriction on the ability to bring a claim, not a mere procedural restriction, and therefore Article 6 did not apply. I won't take your lordships back to the passages my own friend took you to them. Lord Mance at paragraph 11, Roman 5, at bundle page 1160, referring to even under the case law of the European Court of Human Rights as a substantive bar to liability or adjudication, referring to Roach, and finding that on this basis foreign act of state, even if it had been otherwise applicable, would not engage Article 6. And Lord Sumption at paragraph 282, stating that it is a foreign act of state is a rule of substantive law which operates as a limitation on the subject matter jurisdiction of the English court, referring also, like Lord Mance, to Roach. And the conclusion at paragraph 284, Lord Sumption's conclusion, to the limited extent that the foreign act of state doctrine might apply in these cases, it does not, in my opinion, engage Article 6. Lord Sumption in Bank of Uganda at paragraph 16, on which my own friend relies for this argument, in our submission, clearly describes foreign act of state as substantive. You'll recall, this is Authorities Bundle 523, bundle page 1293, again, not necessary to turn up. The lordships will recall the key sentence which my own friend showed you. These may be substantive rules there may be substantive rules such as the foreign act of state doctrine or procedural rules such as state immunity. That is significant because Lord Sumption was addressing the issue in Bank of Uganda in a case where the Article 6 challenge to an immunity was specifically being addressed and was upheld in relation to the State Immunity Act, given to states in relation to employment claims. Lord Sumption's dicta in our submission accords with his finding and that of Lord Mance earlier the same year in Belhadge. For the appellant's argument to be accepted, your lordships would need to consider that Lord Sumption had changed his mind about the applicability of foreign act of state to Article 6 without giving reasons for doing so, without having heard argument on the foreign act of state point, because that wasn't an issue in Bank of Uganda. Moreover, it is important to note that Lords Mance, Sumption and Hughes were of course considering the issue on the basis of the jurisprudence of the European Court of Human Rights. They refer to Roach, Lord Mance also refers to Markovich, and can I again briefly, I don't think I need to turn up Roach, my own friend took me to it. I would identify two particular points of importance to draw from Roach and for the reason for their lordship's reference to it. First, Roach held that Article 6.1 secured the procedural right to have a claim relating to civil rights and obligations brought before a court, but did not guarantee any substantive content for those rights. In so doing, the court emphasised that although the distinction might be a fine one, it would always be determinative. There's no grey area of arguability. Second, the court held that the starting point in assessing whether any restriction was substantive or procedural was the relevant domestic law, and the court would need strong reasons to disagree with the findings of a superior national court in that regard. And went on, of course, in Roach to hold, in that case, that it would apply the classification that the House of Lords had previously ruled in relation to Section 10 of the Crown Proceedings Act 1947, that it was a provision of substantive law. That's the relevant paragraphs of Roach are 116 to 119 on the first point and 120 on the second. Markovich is important because it shows the European Court of Human Rights considering the application of Article 6 to a domestic act of state-like principle, in that case under Italian law. The analogue with English acts of state in terms of assessing its juridical nature for the purposes of Article 6 is very close. Markovich is at bundle 7, tab 37. Just in the head note, perhaps is easier to start with. On page 2144, the applicants were citizens of Serbia and Montenegro. H2, in May 2000, the applicants had issued proceedings against the Italian Prime Minister, the Italian Ministry of Defence, and the command of NATO allied forces in southern Europe in the Rome District Court, contending that they were responsible for the deaths of their relatives. The government of Italy disputed the jurisdiction of the court, and in June 2002, the Court of Cassation confirmed that the Italian courts had no jurisdiction to hear claims arising out of the hostilities, as domestic law did not recognise claims in such circumstances. If your lordships go over to bundle page 2176, paragraph 100 of the judgment, you will note, and this is important because my own friend only focused on one of the, in fact, two bases on which the applicants brought their action for damages. Paragraph 100, in the instant case, the applicants brought an action in damages in tort against the state under Article 2043 of the Civil Code, and also relied in their claim on Article 6 of the Criminal Code, Article 174 of the Wartime Military Criminal Code, and on the provisions of Protocol Number 1, additional to the Geneva Convention 1997 and of the London Convention of 1951. The reason I emphasise that, we'll come back to that in a moment, is because your lordship will recall that what my learned friend said about Markovich is, oh, but this was a case where the applicants had no claim under Italian law. But in relation to the first basis of that claim, that is not the case at all. They were bringing an action in damages in tort under the what is presumably the general delict article of the Italian Civil Code. And you can see how this is dealt with by the court. First of all, over the page, paragraph 106. Sorry, forgive me, I should have started with 102 on the previous page. Accordingly, Article 6 is applicable to the applicant's action against the state, and the court dismissed the respondent government's preliminary objection on this point. It's therefore examined whether the requirements of that provision were complied with in the relevant proceedings. Paragraph 106, the Court of Cassation considered the answer to be clear, which explains why it rejected this jurisdictional point in rather summary terms. It found as follows: the impugned act was an act of war. Since such acts were a manifestation of political decisions, no court possessed the power to review the manner in which that political function was carried out. So the Italian...
So could you read on?
Yes. Further, the legislation that gave effect to the instruments of international law on which the applicants relied did not expressly afford injured parties to a right to claim reparation from the state for damage sustained as a result of a violation of the rules of international law. Thank you. I should have read that, that passage that my own friend read yesterday. The first, in other words, the first finding applying to the tort claim, that the claim could not be, the tort claim could not be advanced because it was based and impugned an act of war. And secondly, in relation to the attempt to say that there could be a claim for breach of the three instruments that on which that's the second cause of action, as it were, was relied on, that legislation did not afford the injured parties a right to claim reparation. In relation to the first point, the answer to the tort claim, that aspect of Italian law is perhaps more closely analogous to what we would call Crown Act of State, as found in Nissen and the Attorney General. But as we know from Aramatula, the case decided by the Supreme Court with Belhaj, the concepts of, in English law, of Crown Act of State and Foreign Act of State have common juridical strands and are both rules of substantive law. The court's reasoning in Markovich, if your lordships would turn it over to page 2178, my learned friend read you yesterday paragraph 114. Could I ask the court to read 113 and then reread 114? Lords, it is not difficult in our submission to see why Act of State, Foreign Act of State, must, for Article 6 purposes, be characterised as substantive, because in contrast with sovereign immunity, which is a jurisdictional immunity, determined in English cases at the outset always, and which, if upheld, bars the court from proceeding with the claim, Act of State is a substantive defence. It can operate positively or negatively, depending on the way in which it arises. It can arise so as to require an English court to give effect to a law. It can be used, perhaps, one might say, as a sword, not only as a shield. It can require an English court to give effect to the consequences of an executive act. It thus may enable a claim to be made. The law or executive act may form an ingredient of the claim. I gave an example earlier this morning of a case in which a claimant is founding a claim on title to property which it has acquired under legislation, foreign legislation, or a foreign executive act. The basis of the Foreign Act of State rule, as explained by Lord Lloyd-Jones in paragraph 135 of Maduro, is important in this regard. It is an exclusionary rule that operates by reference to issues as to legality of conduct of foreign states. The appellants, as I say, have to contend that Lords Mance, Sumption and Hughes were wrong in their conclusion on the point, though obiter, but after full argument, and that you should find them to have been wrong because of something said by Lord Sumption, the same Lord Sumption, in a judgment not very long afterwards. That would require you to consider that Lord Sumption had reversed his position on the application of Article 6 to Foreign Act of State 6 months after.
You made that point already.
Lord, I have. Sorry, but just simply to add to that. First of all, that he did so in circumstances where, without saying that he was doing so.
I think we've got the point, Mr. Smoothwell. Even if Homer nodded, he's unlikely to have nodded twice.
Very well, I won't make the further points. You have my points in relation to that. My Lords, just so you have them, the dates of the judgments. Judgment in Belhaj was on the 17th of January 2017. Benkabush, June 2017. Argument in Benkabush, June 2017, and judgment in October. My Lords, for those reasons, we would invite the court to dismiss the appeal on all grounds, and unless the Lord has any further, my Lord, I will leave to Mr. Chalfoun, my own friend Mr. Chalfoun, if he has anything to add.
Thank you very much.
I'm grateful.
Mrs.
My
Johnson.
Lords, you have my skeleton argument. Unless there are any questions, I will adopt the submissions of Mr. Smooth.
We've heard detailed submissions from Mr. Smoothwell. I'm sure you adopt them all.
Invite you to discuss.
Thank you very much indeed. That's very helpful. Would it be sensible if we sort of broke now, Lord Panning?
Certainly, my lord.
Just so we don't interrupt your flow, as it were. Thank you. 5 minutes then, please.
very much, my lords. My learned friend Mr. Smoohar began his submissions yesterday by making some observations about our case as argued below on Commercial Act and about whether this was a pleaded case about corruption. And may I begin just by reminding your lordships that our case below on Commercial Act, which is the first issue I want to address, is the same as the case I presented on Monday afternoon. And I invite the court's attention to Supplementary Bundle Volume 2 at tab 19, paragraphs 45 to 49. This is the skeleton argument below.
Yep.
And paragraph 45 in the fourth line talks about the core of the case. The core of the case is an allegation there was a corrupt agreement. And then 46, how does that give rise to liability? And 47, given that the sale of CBL's assets to DFC Bank was effected pursuant to a private law agreement, it's very difficult to see how the Foreign Act of State doctrine could bar the claim. It's common ground the BOU can enter into private law commitments and relationships and be sued on them. Asset sales are such commitments. They are things that private parties can and do enter into all the time. They're not sovereign in character. And over the page, 48 says corruption doesn't matter for that purpose, and 49, the context being the statutory management and receivership does not detract from the private law character of the transaction, just as the context did not do so in other cases. And they're the ones I referred to on Monday afternoon. That was our case below, and it remains our case now. And our case as pleaded is focused on corruption. I'm not going to read out all the passages in the pleading, the re-amended particulars of claim, but paragraph 69A Roman 2 and Roman 3 and 69M Roman 1, 2, 3 and 4 are all pleas of corruption and bribery. And I therefore do not accept my friend's complaint that in opening this appeal, when I said it's a case about corruption, I was in any way misaddressing the case as pleaded. Corruption is also an express central part of the claim form, which is at page 83 of the core bundle, paragraphs 2 to 3 and 5 to 6. My friend emphasised that our pleading extends far beyond what could be sustained in relation to a Commercial Act exception. And he's right. And the reason why our pleading extends far beyond a Commercial Act exception is because the pleading proceeds, and the court will say rightly or wrongly, on the basis that public policy applies and or Article 6 applies. Yeah. And so there is no FAS limit to what we can invite the court, the trial court, to decide. Of course, if we need to rely on the Commercial Act exception because we're wrong, if the court says we're wrong on public policy on Article 6, then we are confined to what can properly be categorised as commercial. But then, as my Lord Justice Phillips put to my friend in argument, the greater must include the lesser. And our core case would remain a bribe was paid, the sale by BOU at an undervalue resulted. Now, in relation to whether we can establish that there was here a Commercial Act, we rely on the act of entering into the P&A agreement. And we're grateful to my Lord Justice Phillips for asking to see the agreement because we say it confirms our submissions. And it does so because, I don't know whether your lordships have it available, this is this agreement, P&A agreement. I'm grateful. Page 3 identifies that the Bank of Uganda are acting as receiver. The recitals set out the history. And then we have the content of an agreement, which in my submission is in a standard commercial form that would apply to the sale of assets by any other receiver. We draw particular attention, my lords, to paragraph 1.4 on page 7, which asserts that the parties hereby agree that this agreement is a complex commercial contract, etc. The antithesis of a sovereign act. And we also draw attention to paragraph 24.2, which contains a standard form arbitration clause. And again, in my submission, this is the antithesis of a sovereign act. We
What about
say,
even more pertinent is that the receiver is giving warranties.
yes, indeed, also given warranties. I'm grateful to my lord, as one would expect in a commercial agreement of this sort. So there's nothing in this agreement which supports the suggestion that it is a sovereign act, and there's much to support our contention that it is a commercial act.
You skipped over the recitals quite quickly.
Well, the recitals set out the history.
B identifies that the bank purports to be acting in the interests and for the benefit of the depositors,
Yes.
as well as the creditors, but C, perhaps the most important, it's exercising its authority in the interests of the public and of the financial sector in Uganda, and that those are the interests which drive the entering into the agreement. So we haven't got to the stage of a defence yet, but it might be a defence. But it doesn't matter if there's a sale at an undervalue. That would be the critical question for a receiver. But if it's in the interests of the stability of the Ugandan financial market, then that's an answer. And if the exercise of the powers was, I've forgotten the number of the section, but subsection 2A through to
Section
D.
95.
Section 95, thank you. Would that not be an answer?
There's a lot of ifs in your lordship's question. If we go to section 95, which your lordships have in supplementary bundle volume 1, tab number 10, it's at page 174 of the electronic bundle. Your lordship is rightly, correctly directing attention to the reasoning of the central bank at 95.2. The central bank shall take the action described in subsection 1, which in the opinion of the central bank, A, B, C and D. And we can see from the recitals that consideration has been given to that. My submission is that that decision is not what we're challenging. What we are challenging is the act which clearly is consequential, clearly has a causative connection with the 95.2 reasoning, but it's the decision taken under 95.1b to arrange for the purchase of assets and assumptions of all or some of the liabilities by other financial institutions. And the agreement is a distinct commercial act which is then entered into. The motive for it, I entirely accept, is the reasoning of the central bank set out in 95.2. But it's not in dispute, nor could it be, that the motive for which the relevant act is entered into is nothing to the point. That's what Lord Wilberforce established. And to focus.
But the question is whether it's something that a private actor could do. And if, to take a perhaps a slightly more extreme example, the government regulator said in relation to Credit Suisse, we're going to sell the assets for £1, not because they're not worth a great deal more than that, but because we've got to do this over the weekend to stabilise markets, then that wouldn't be something, a sale of that nature is not something that a private receiver could do, is it?
Well, it may be, as in many of these FAS contexts, that much depends upon the facts. And the facts have not been found. But what I don't accept is that it can be appropriate to say to us that what appears to be, very clearly appears to be a commercial act by reference to its character, ceases to be so by reference to what went before and the motive for which the Bank of Uganda entered into that otherwise private law agreement, which had all the incidents of a private law agreement and which created, there's no dispute at this stage, created private law rights and duties. And my friend accepts, as he must, that whether an act is commercial depends on the nature of the act. And he accepts, as he must, that the motive of the public body is irrelevant. His case is that the entering into of the P&A agreement is a sovereign act because of the context. And he points out, and your lordship's putting to me, that the context includes the regulatory regime by which powers were conferred on the BOU and were exercised.
I wonder if this question really arises, because it seems to me there's an express plea at 40A that as a matter of Ugandan law, the duties imposed upon the BOU as receivers include taking reasonable care to obtain a proper price. My understanding is that we're not departing from the pleadings for these purposes. So I'm not sure one can say here that the BOU is entitled to sell these assets other than at a proper price.
Yes, and that of course would be the obligation of any receiver. Any receiver who didn't act in that way would be acting unlawfully.
It also seems to me we've got an agreement here to which the defendant is party, in which they've expressly agreed that this is a commercial contract.
Yes.
It may not strictly be in the stop rule, but it seems to me at this stage of proceedings for the defendant to be arguing this isn't a commercial contract might seem to be rather difficult.
Well, putting it at its lowest, I do respectfully submit that there is sufficient here to go to trial. The facts may look different, I entirely accept. The facts may look different after evidence has been heard. But at this stage, I say either that this is a commercial act as a matter of character, or the court cannot say, will not say, that prior to trial it is not a commercial act. I do also submit that it proves too much to say that the entering into of this commercial agreement was the exercise of a statutory power. It proves too much because what is otherwise by character a commercial act, for example, to use my Lord Justice Phillips' example, and Lord Denning's example, the purchase of boots by the army, which is plainly a commercial act, does not become a sovereign act because the public body concerned, the army, is authorised by statute to enter into such a contract. There may be an express statutory provision that confers power on the army to enter into such a contract. But what matters is the character, the nature of the act that they have entered into. Here, the private law agreement. And it is in my submission important to note the role which Lord Wilberforce attached to context. He said the context has to be taken into account, but the focus is on the act upon which the claim is based. The question is whether that act in context is commercial. In E Congresso, what is said by Lord Wilberforce, I won't turn it up again, but I'll give the reference, volume 1, tab 6, and it's page 267, B to C of the law report. He says the ultimate test is whether the act, quote, of its own character is private or commercial. And we say that is so in the context of this case. An act which is otherwise of a commercial nature does not cease to be so because it is the culmination of a scheme which involved earlier sovereign acts. And if your lordships will forgive me, it is necessary just to go back to Kuwait because I need to clarify something that my friend said about the link between the later stages and the earlier. It's Kuwait is in volume 1 of the authorities. It's a tab 9, my lords, and the relevant passage in Lord Gough's speech for the appellate committee is at page 1163 of the law report. Volume 1, it's tab 9, it's 1163, and it's at page 330 of the electronic bundle. And Lord Gough, at the top of the page, says he approaches the matter as follows. First, the taking of the aircraft and their removal from Kuwait airport to Iraq constituted an exercise of government power by the state of Iraq. And then he deals with the submission. And he says 5 lines down, but I am satisfied that in so acting, IAC was not just doing a job of work, but was closely involved with the state of Iraq in the last stage of an enterprise which entailed both the seizure of the aircraft and their removal to Iraq to be used for such purposes as the government of Iraq should direct, which in point of fact was to be their incorporation into IAC's fleet. And so to the extent my friend was suggesting to the contrary, what Lord Gough says is very clear that the civil use of the aircraft in Iraq was the culmination of a scheme that had been devised from the beginning. And therefore I say it is no answer to our contention that the P&A agreement is in its character a private law, commercial agreement, to say, well, on our pleadings, it's the culmination of a scheme that can be traced back. You still have to look at the nature of the relevant act, here the P&A agreement. My friend then drew attention and relied upon, or rather the court drew attention, my friend relies on the side letter. Again, if we're correct on public policy or Article 6, we're entitled to rely on it. If we're just looking at commercial exception, we say that the sale of CBL's assets is effected by the P&A agreement, and only by the P&A agreement, with the BOU acting in its capacity as receiver. The side letter concerns concessions made to DFCU Bank by the BOU as regulator. And in a case where bank assets are sold to another bank, the regulator will often be involved to ensure regulatory compliance, just as on the sale of business, the competition authority may be involved as regulator.
I'd quite like to see the side letter.
Sorry,
I would quite like to see the side letter.
well, indeed, it is. I think it's. Is it a what else we have? Your Lordship did ask. I thought it had been provided, but
Okay.
it had not. I'm sorry. Can we hand up? Thank you very much.
Do you say there's a clear distinction between its role as receiver, as per the sale, and the separate accommodations it made as central bank?
As regulator.
Regulator.
It's headed compliance accommodations. The first paragraph at the end of it, BOU acknowledges that certain accommodations are necessary to be given to DFCU in relation to compliance with prudential requirements, reporting requirements, and AML KYC compliance. And that agreement, whatever one may think of it, it doesn't alter the commercial nature of the P&A agreement by which, and only by which, BOU sold the assets of CBL as receiver. And our loss, our pleaded loss, was caused by the P&A agreement. That's our case.
The pleaded case is that it was the side letter that enabled the acquisition of the assets at a substantially lower cost.
Yes, but we plead, indeed, that it is the sale which caused the loss, the P&A agreement sale which caused the loss. That's our case.
Well,
And I say
the
this,
side letter enabled sounds like a causation argument to me, but that's...
yes, but I've made the point that if we're going to adopt a causation approach, then one can trace back a number of sovereign acts which does not remove the characterisation of the act of which we complain, which is here the sale. So causation, in my submission, is not the answer. My friend then suggested the court should not or could not allow part of the claim, that concerned with the P&A agreement, to go forward as a commercial act if we're wrong on public policy and Article 6. But that is precisely what the Supreme Court permitted in the Ukraine case, where it found in favour of the Kirkpatrick exception on a limited basis relating to duress and allowed only part of the case to go forward. Perhaps we should just go back to that. It's volume 7 of the authorities, my lords. At tab number 35, and the relevant paragraphs in tab 35 of volume 7 are that justiciability the foreign act of state issue, the court addresses it, begins to address it at page 2063 of the electronic bundle at the bottom of the page, paragraph 184. There's a citation of authorities that are now all too familiar, or were in any event very familiar to this court. And the sorry, my lord, it's tab 35,
Yeah.
picking it up at 2063. The bottom of that page, paragraph 184, is headed justiciability. There's then a recitation of relevant passages from Belhaj, from Kirkpatrick, etc. And at paragraph 191, which appears on page 2067, we have the conclusion. In short, the act of state doctrine is not engaged by the defence of duress now put forward by Ukraine, because that defence does not place in issue the validity of any foreign sovereign act. Having reached that conclusion, it's unnecessary to consider public policy and commercial exceptions. So that's the ruling, and the consequence of that at 194 over the page 2068, conclusions. For these reasons, we conclude that Ukraine's defence of duress, so far as based on the threats of the use of physical violence towards Ukraine's armed forces and civilians, and the threats of damage to or destruction of Ukrainian property, which were allegedly implicit in the threats allegedly made on behalf of the Russian Federation, cannot be determined without a trial. On that ground alone, the trustee is not entitled to summary judgment. And the consequence is at 197 over the page, electronic 2069. 197, Ukraine will have to amend its pleadings so as to focus more clearly than at present its case of duress of the person and of goods based on those alleged threats. Its averments of fact in relation to in respect of the alleged trade restrictions are also material. On the other hand, its averments in respect of other matters introduce issues which are not material to the defence of duress and on which it's unnecessary and appropriate for the court to make any determination. Those averments ought not to go forward for trial. So the Supreme Court recognised in this complex area that the appropriate step to take was to allow the party to amend in accordance with the ruling of the court on what was permissible and what was not permissible. It's also, for good measure, what the appellate committee permitted in the Kuwait case. If we go back to Kuwait, volume 1 of the authorities, tab 9, Lord Goff, at page 1164, page 331 of the electronic bundle, page 1164 of the law report, tab 9, law report 1164, electronic 331, Lord Goff's conclusion just above C, for these reasons I'm satisfied IAC cannot claim state immunity in respect of the allegations made in C and D of the particulars, insofar as they relate to acts alleged to have been performed after the coming into effect of the resolution. And at 1167, at the bottom of the page, electronic 334, the bottom of page 1167, 4 lines up from the bottom. Second, the action should now be remitted to the commercial court, so it may now proceed against IAC in relation to those parts of the claim in respect of which IAC cannot rely upon state immunity. The matter can then be fully pleaded in the ordinary way. When this has taken place, it will be for the judge to decide in the light of submissions how he should deal with the point on justiciability, having regard to the limited context to which that point is now set, following IAC's partially successful plea, etc., etc. So the court there and in Ukraine adopted what I would respectfully submit is a sensible approach of allowing the parties, in the light of the determination on jurisdiction, to get the pleadings in order. Any other approach, I would respectfully submit, be a triumph of form over substance. My friend then took...
I'm sorry to slow you down.
Not at all.
But can you give me just some sense of how that works? Suppose that none of the exceptions apply and we're dealing only with the Commercial Act, and it is, at least at the moment, arguably a Commercial Act, so that the allegation that the sale was at an undervalue,
Yes.
as the conspiracy goes forward. What else stays with it? For example, does it still permit investigation into the otherwise sovereign acts, because one of the motives is said to be to cover up previous wrongdoing, or because that is all, you would say, motive for what is a commercial act? How far does it go?
Well, I would submit that we're still entitled to plead the context in which the Commercial Act arose. The court would not wish to be blindfolded, but the court would be prevented by a foreign act of state from making any determination which in any way makes findings against the Bank of Uganda in relation to those matters. And we would need to produce an amended pleading which respected that limitation. One further point on Commercial Act, and it's this: my friend took the court through the various hearings before Mr. Justice Salter. Those hearings were not concerned with our more limited case, that is, if we're wrong on public policy in Article 6, that we can succeed by reference to the Commercial Act of sale of our assets, what we describe as the Commercial Act of sale of our assets. There was no concession, there was no assurance in relation to not pursuing any such contention. Indeed, there was no discussion of that topic, unsurprisingly, because the hearings before Mr. Richard Salter were not concerned with FAS issues. It wasn't the issue. They were concerned, his lordship was concerned, with the need to clarify the pleadings, first to make it clear that we're not seeking to hold the defendants liable for acts which occurred prior to their involvement. That is now clarified by paragraph 69A of the re-amended particulars, and we also made clear by paragraph 69 as re-amended that we are contending for an alternative case, that there were two conspiracies rather than one. So those hearings add nothing. My Lords, Kirkpatrick, I do not believe I can add anything of value to what I submitted in opening. Unless your Lordships wish me to address that point further, that's what I wanted to say. I don't resile from it, but I don't wish to go over it again. Public policy, my Lord. I respectfully submit that my friend's approach to public policy seeks to confine a principle which is designed to be flexible and designed to move with the times by restrictions for which there is no authority or which are contrary to the authorities. And my friend does accept, and very properly accept, that none of the authorities addresses, far less rejects, the possibility that corruption of state officials may, at least in some circumstances, and I emphasise in some circumstances, form the basis of a public policy exception. And I do respectfully agree, by way of submission, with what was said by my Lord Justice Phillips, or suggested by my Lord Justice Phillips in argument, that the principles stated by the Appellate Committee and the Supreme Court are open textured in nature. And I would also respectfully agree with the suggestion made by my Lord Justice Popplewell to my friend, that it's very important to bear in mind that facts alter cases. My Lord Justice Phillips drew attention to two such statements in Belhadj. My Lord drew attention to Lord Mance at paragraph 107 Roman 5, which is Law Report page 1109 A to B. And my Lord Justice Phillips also drew attention to Lord Sumption at paragraph 267 at page 1167A. Could I add to those statements the observations to like effect by Lord Newburger for the court? If we go back, please, to Belhadj, which was volume 4 at tab 22, the relevant passage in the judgment of the President of the Court, Lord Newburger, speaking for the court, is at page 1111. It's paragraph 118, 1111 of the law report, 1209 of the electronic bundle. And at paragraph 118, the court has already seen the opening section that the doctrine applies to claims which, while not made against the foreign state concerned, involve an allegation the foreign state has acted unlawfully. And then this, insofar as it is relied on in these proceedings, the doctrine is purely one of domestic common law, the court has that point, and it has all the advantages and disadvantages of a principle that has been developed on a case-by-case basis by judges over the centuries. Thus, while it is pragmatic and it's adaptable to changing norms, as Lord Wilberforce pointed out, it is a principle whose precise scope is not always easy to identify. And the consequence of that, in my submission, is to like effect to what is said by what was said by Lord Mance and Lord Sumption, that one must, in my respectful submission, be very careful not to rule out or rule in statements of principle without having regard to the facts of the particular case. And my Lord Justice Phillips asked the question, I think this morning, if corruption, why not fraud, which does not involve corruption? And there are two answers that I would respectfully give. The first answer is that corruption of state officials is so destructive of the rule of law and of the economies of civilized societies that it does fall into a special category. And that is the point of the international materials which I showed the court. I wasn't seeking to establish that there is some binding legal obligation on the courts of this jurisdiction established by treaties which have been incorporated into domestic law. My point is that all of those materials establish that we are dealing here with a mischief of such a special gravity that the public policy of this country will not tolerate the use of act of state in order to prevent a claim being made so that the mischief can be remedied. But there's a second answer to my Lord's question, and the second answer, which your Lordships were putting to my friend, and I would respectfully adopt. This case falls into a narrower category, which suffices for our purposes. And the category is corruption to line the pockets of officials, not to implement the policies of the state, even arguably on the pleadings. And the issue is whether a public policy exception should apply or whether it's properly arguable that such an exception should apply. And I drew attention in my opening, either on Monday afternoon or I think Tuesday morning, to the basis upon which Lord Justice Males had given leave to appeal.
Yeah.
And it was core bundle tab 8, page 152, and the court recalls that his lordship, my submission, rightly focused on the issue of whether the Foreign Act of State principle applies, quote, to a case involving the corrupt misuse of executive powers for private gain. And that's what this case is about. And the court need decide no broader principle than that. The facts matter. The principle will need to be assessed. It will need to be developed in the light of the facts that are found. And of course, there is a particular potency in the reliance on an exception, a public policy exception in that context, because the whole point of the FAS doctrine is international comity. And to the extent that we can sustain our plea that the corruption by the public, of and by the public officials, was for private gain, any argument as to comity is very, very substantially reduced if it applies at all. And I'm asking this court, I made this point on Tuesday morning, I recognise that this court will be reluctant to decide, particularly in limine, a question of this significance. And I'm asking the court simply to recognise that there is sufficient here to allow this case to go to trial so that the facts can be found, and if the facts are in our favour, for the principle to be applied and developed accordingly. And that's what Lord Collins recognised was appropriate, where there is a difficult point of law, novel and difficult point of law, the application of which may well depend on the facts, in Ultimo, Volume 3, Tab 17, paragraph 84. So I'm not contending, as my friend suggested, I'm not contending for a principle of public policy that will always require that act of state does not apply whenever there is corruption. I'm contending for a much narrower principle. And I also submitted in opening, and my friend didn't challenge this, there's no criticism of him, but I also showed your lordships in opening that there is authority. Mr. Justice Marcus Smith in the High Commission of Pakistan case, Volume 5, Tab 25, that there's a need for a balance of interests in relation to public policy and act of state. What I don't accept, respectfully, is my friend's contention that public policy is limited by either a principle that there must be, to quote my friend, engagement with a rule of the constitutional order, unquote. No case so restricts the public policy exception. It's difficult to see how the Makhtoum case, for example, on phone hacking, falls within that. There's no requirement to show that an international convention requires, my friend's approach, requires an exception to FAS. On the contrary, in Belhaj, their lordships, Lord Neuberger, Lord Sumption, emphasised that there's no need to show an international law obligation. Your lordships have seen the passages.
Well, Mr. Smuhar didn't actually address Al Maktoum at all.
No, you didn't.
And in might be said that's an example of the misuse of executive powers for private gain,
Yes.
albeit not financial, but other personal private gain.
Well, your lordship will recall there was no suggestion in that case that this was that any acts had been carried out in the public law interests
No.
of the UAE. That was no part of the argument.
Yeah.
And of course, that case is binding on this court as a judgment of the Court of Appeal as to the modern width of a foreign act of state. But no need to show an international law obligation. Belhaj, Lord Neuberger, paragraphs, Lord Neuberger repeats the point, 153, 154, 155 and 168, and Lord Sumption at 261. My friend also said the exception requires engagement with some fundamental principle of justice. Well, I say corruption of and by state officials for private gain falls well within any such test. My friend then addressed the relevant materials. I'm going to deal with this very quickly because your lordships have seen all the materials twice. The Bribery Act, yes, it does concern criminal liability for conduct in this country or by those who have a relevant connection to this country. My point is that Lord Sumption recognised in Belhaj, paragraph 266, that it's no answer to say the provisions are concerned with criminal law. He said the criminal law reflects the moral values of our society and may inform the content of its public policy. And I repeat the point, if my friend is correct, then there will be cases where there can be criminal prosecution, but no civil law remedy. In relation to the international materials, I've already said in my reply, I'm not suggesting that they create binding obligations on this country, far less on the courts of this country. My point is that they recognise repeatedly from the preamble to the UN Convention, which my friend did not address, through all the other materials, including the statement of Jack Straw to His Majesty's Government's recent anti-corruption strategy, they all recognise the severe damage to the international order and the rule of law of corruption. And I say those are factors that the court will take well into account in deciding the public policy of this jurisdiction. That's what I wanted to say on public policy, unless I can assist further on that, my lords. Article 6 I can deal with very briefly. The dispute is a narrow one, but an important one. No dispute between us. Article 6 is not engaged if the limitation or restriction is substantive, not procedural. Only engaged, Article 6, if the restriction is a procedural one. And I say that the meaning of those terms, procedural and substantive, is identified for the Supreme Court by Lord Sumption in Bank of Uganda. Can I, for the last time, please invite the court back to volume 5 of the authorities, tab 23, paragraph 16, which is on page 799 of the law report, page 1293 of the electronic bundle. And my friend, understandably, drew attention, as I did in opening, to Lord Sumption's statement at 16F, just under 16F, that these may be substantive rules, such as the Foreign Act of State doctrine. But he's dealing with how domestic law looks at the matter. And then just above H, he says, but, these are not refinements with which the Strasbourg Court has traditionally been concerned. What the Strasbourg Court means by a procedural rule is a rule which, whether technically procedural or substantive in character, has the effect of barring a claim for reasons which do not go to its legal merits. That is to say, rules which do not define the existence or extent of any legal obligation. And our point, it's a very short point, but it's not been answered, is that we, with great respect, do not understand how the FAS rule can be said to be a rule which bars this claim for reasons which do go to its legal merits. The legal merits of our claim under Ugandan law are not in dispute, certainly at this stage. And on Lord Sumption's test, we say that this is a procedural restriction and therefore Article 6 applies. It's as simple as that. And nothing that my friend submitted addresses that core point. Of course, as he rightly emphasises, understandably emphasises, in Belhaj, Lord Sumption and Lord Mance took a different view. But with the greatest of respect, I say that their approach cannot be reconciled with the test that Lord Sumption set out in Bank of Uganda, and therefore this point too, if we need it, should be allowed to go to trial. That's what I say on Article 6. Lords, I've tried to cover the ground efficiently. If there are other points, I'm very happy to try to address them, but that's what I wanted to say by way of reply.
I don't know if my lord has got any further questions. I don't.
Could I just ask one point?
Yes, of course.
Mr. Smoothar said that we must take it that if there was a tort of bribery recognised in Ugandan law, that you would have pleaded it. I have to say I find it surprising, given what we've seen in Ugandan law, that it wouldn't recognise a tort of bribery. But there's nothing more you want to say about that.
There's nothing more I want to say, my lord. I mean, the fact of the matter is we haven't pleaded it. And I told your lordships yesterday we've considered it, and we're not seeking permission to amend our pleadings at this stage. I hope that answers your lordship's question. It may well be that there is such a talk, but I'm not in a position to assist further on that.
I think that's right.
I'm very grateful to your lordships for the court's patience.
If your lordships will allow me, can I just say in relation to Almac 2, which I'm not going to address, I didn't address it orally, that's quite correct. It is addressed in our written
It's addressed in your skeleton.
paragraphs 40 and 46, and we certainly would say in relation to that point that what we say there is appropriate.
Right. Well, thank you all very much indeed for your excellent and illuminating submissions. Thank you to all the teams, both counsel and solicitors. We are well aware how much hard work goes into the preparation of all appeals, particularly this sort of appeal. We will reserve our judgment. You won't be surprised to hear we're not going to deliver judgment on return, especially not a quarter to 4. And you will receive that in draft in due course. Please pay attention to the embargo at the top of the judgment, which has been strengthened by the Court of Appeal. I'm sure you're all well aware of that. And in the usual way, the point of having the draft is to point the court towards any typographical errors or some obvious other error, not to invite the court to receive further submissions or change what it said in substance. And if, when the time comes, you can endeavour to agree a form of order, that would be helpful. If you can't, then we will deal with anything outstanding on paper. But thank you all very much indeed, and only remains for me to wish you all a happy vacation.
Thank you very much, Lords. pleasure. Maybe you can